I'm gonna get started. So today I'm gonna talk to you guys briefly about the HIPAA basics. Someone tell me, what does HIPAA stand for? We say it all the time. What does HIPAA stand for? Anybody?
Health information.
Health.
Patient IT.
No.
It's Health Insurance Portability and Accountability Act. So HIPAA is the Health Insurance Portability and Accountability Act. It's we say it all the time. We bounce that word around, but we don't really think about what it means. But HIPAA has a few different components. The first component is the portability standards, and this just ensures the continuing of healthcare. The second one is the privacy standards. This is the standards that pretty much govern the disclosure of any type of protected health information. And then lastly is the security standards, which protects the development and maintenance of health information. So I'm gonna go over each part. For part one is the healthcare portability. HIPAA was enacted in 1996. The purpose is to ensure the portability of employee health coverage by one, limiting the ability of a new employer plan to exclude coverage for pre-existing conditions. It prohibits discrimination against employees. And the most important protection under HIPAA is that it helps those with pre-existing conditions to get health coverage. Part two is of the privacy standards, is the national standards for the protection of certain health information. The privacy rule standards addresses the use and disclosure of protected health information, which I'm going to be addressing moving forward as PHI. The major goal is to properly protect an individual's health information. So one thing I do want to kind of add is, just as healthcare workers, we have to be careful of what we're disclosing in terms of the client's information. I hear, and this is something that I hear people say all the time, HIPAA, but sometimes, I guess the truth be told, we don't really know what HIPAA is. We just say it. We know it's about privacy, but just really knowing, like, you shouldn't be on the sidewalk disclosing what type of diagnosis a client have, even if it's a mental health diagnosis. We shouldn't be on the sidewalk talking about any type of information pertaining to a client, because that is a violation of HIPAA. So I just want to kind of point that out. So HIPAA does place certain restrictions on the disclosure of PHI. And PHI is any type of information about a person's health status, their provision of healthcare, or payment for healthcare that can be connected to a person. So how a person gets their healthcare paid for is also a part of the PHI section. PHI also includes any part of a patient's medical record. So again, just making sure that we're being careful of what we're disclosing. Sometimes I know a client the clients like to say, my insurance paying for this, that. That's something that we shouldn't even be like getting into discussion with them about. More things about what the protected health information includes any information about a person's past, present, or future health plans, their name, their address, any type of dates related to the individual, including their birth date, admit date, discharge date, their phone number, email address, social security, or a patient's photograph. So it's also important, like when you're using like the laptops, that you're being careful of like what you're allowing to be displayed. That's something to be kind of aware of. Also, when you're on your computer, if a client comes in, making sure that whatever you're doing, that you have your screen kind of minimized, that no type of like opus information that's showing any type of client data is pulled up. Something to be mindful of too. So some general rules for use and disclosure of protected health information. There are many exceptions to the requirement, including if the individual asks for certain information, like they can ask for their treatment plan. Now with the therapist, it is technically it's up to the therapist's discretion in terms of the therapy notes. Because you have to be careful with notes, because it can be kind of counterproductive if you give a client, a note and we chart to the negative, right? So if they see something and it's charted to the negative, it can cause like a ordeal for them. We have to remember we are in mental health, so we just have to be careful with, providing them with their, therapy notes, the individual notes, group notes. That's kind of at your discretion. So they technically do not have to have access to the therapy notes. I don't know if everybody was aware of that, but that is, actually factual. I know a lot of times we just give it, but we have to be careful with that. I think it's important to kind of read over what you're giving them, because again, if it's something that's charting to the extreme negative and they see that, it can cause a big ordeal. So just be cautious when providing them with like therapy notes. That's something that we can kind of talk about beforehand. Incidental uses of PHI. Oh, I want to go back. So basically, it's just important to use your professional judgment when giving the minimum necessary information to the patient. Just be aware of that, using your professional judgment. Incidental usage of PHI, this is when information is disclosed inadvertently, for instance. So if an individual not directly involved in the patient's clinical care is requiring certain documentation, which we get that a lot, such as for billing or a diagnostic code. Again, that's something that you can kind of consult with us about, and we can kind of figure out. It depends on who's asking for it, what they're asking for it for. Because I know a lot of times we have judges needing information, stuff like that. So that's a case by case. You can just kind of come to me and we can kind of look at the situation. Here are some reasonable safeguards that we use here at Progressive. One is we allow the clients to have IDs, so that way they don't have to, because I know the other day a patient was saying that they weren't very comfortable with saying their birthday out loud. And they have that right to not, they don't have to say it out loud if they're not comfortable. So they do have an ID card that they get upon admission from case management, and they are welcome to show that to the techs, to nursing, as a way to identify themselves. So they don't have to say their birthday out loud if they're not comfortable. That's why they have the ID. I know that was an issue, someone mentioned in community that they weren't too comfortable giving out their birthday, and they have that right. Also using the first name and the first initial of the last name. That is a way that we can help the clients kind of safeguard their information. We use noise machines in therapy sessions. I know, Bailey, you have the noise machine, which works very well. That way, when you're having sessions, they're not, like, information that's disclosed is not being heard from the other offices, because that is their private session, and no one should know what, client A, client D have going on outside of the therapist in that therapy session. We have private counseling areas, the offices, private, again, if we need to have noise, the sound machines to kind of help other people from listening or being able to hear what's going on, then we do have that option. Individual providers that are not covered under HIPAA must provide patients with a notice of privacy practices. This type of documentation, it gives the patient details of their rights involving their release of information, which we do have a release of information form. The provider must have a signature showing that the privacy notice was received. The patient can either refuse to sign or they can't sign. So next I want to talk about state law versus HIPAA law. What if they differ? If state law and HIPAA differ, the provider should be safe and follow the law, and whichever law is more stringent. So you have to comply with both the state and federal law. So we always have to go by whatever the state law is. Patient access to their records. This is something too that we deal with a lot here at Progressive. The patients want to ask for their records. They want to get their records. Again, they are limited in terms of like if you want to add the group notes, therapy notes, in the records, but they can get like their psych eval, and things of that nature. So the psychotherapy note exception. The privacy rule does not require that patients have access to psychotherapy notes, which I kind of got ahead of myself talking about. But this can vary from state to state, but in general, your case notes, group notes, individual notes, it does belong to the provider. And the provider does have the right to restrict them. So it really depends, because if it's like something dealing with, like a court case or something like that, if you feel that it's necessary, then you have the right to provide it. So it's up to the clinician. Any questions so far? I know that's a lot of information. Bailey?
So in the case that I came to you today with a client's family member needing information about the client's treatment and admission dates, they had previously given me permission on the patient family note, but I had never gotten them to sign an additional consent form for that information. So if I'm giving information to a family member with previous consent just because they are the family contact, do I also have to create a consent form if I'm giving them information about the client?
I would definitely go back to the client and get them to give you additional consent.
Okay.
Because I know looking at that form, it was more detailed in that than just saying, hey, I'm just giving you permission to update on how he's doing in treatment. So I would get an additional, just to cover your, that's one thing in this field, we have to make sure that we're covering our basics, like we're covering us. So to cover you, yes, I would go back, even though he said it's okay, I would get it in writing just before you send it over to her. And if
They've already done it, but I will get consent.
you can get, but you know that he's okay with it, so just get him to write, just use the consent form and just put what you, like, where it said, I think it says like maybe other, and you can just put a little description of what that form was, because that's a different form that we don't typically see quite often. So, I'm glad you came to me and we kind of talked about it, but it's okay.
Okay.
Just, I would just go back and get it and put it in, scan it into his, file. Anybody else? All right, good. All right, so clinical implications of patients reviewing their medical records. So there are no adverse consequences associated with allowing patients to review their records while they're in the medical setting. However, there are more risks for psychiatric patients. Reports indicate that some patients felt more pessimistic after reading their records, which is what I was kind of getting ahead of myself earlier on, and became kind of upset after reading what their records show. For example, actually had this happen last week. Linda, we all know she's been kind of manic, but she came to me and said, the diagnosis that's in my chart, that's not my diagnosis. And she was very upset about it. She's like, why am I taking medication for this? I don't have this. So I literally had to go, like, give her psychoeducation on what the diagnosis was, the symptoms. She still didn't agree with it, but that's kind of an example of, like, being careful of what the clients do see in the records, because sometimes if they're not in a good headspace to receive what they're seeing, they get upset about it. So that is definitely facts. It's also important for the provider to discuss the patient concerns with the patients in advance, and again, just limiting access to what they see if you feel that it's something that will be harmful for them. But in this case, it was just a lack of understanding. Part 3, the security standards of HIPAA. The HIPAA security rule establishes standards to help keep patient information safe and to protect information from unintended disclosure. This rule applies both to electronic protected health information as well as if it's a hard copy. This can be healthcare claims, payments, any type of electronic requests for coordination of care or benefits, and any electronic treatment requests. And we get a lot of requests from different like insurances, different, sometimes clients are in different treatment facilities and people they request, their records, and it's certain things that we are required to send. And we only send the things that we are required to send, which would be like their psych evals, and things of that nature. The security standards continue. This rule discusses administrative, physical, and technical safeguards. So again, when it comes to safeguarding, we just have to make sure that we're keeping the clients, each client that we have here, keeping their information safe, like across the board. And I just wanna kind of reiterate, being careful of what we're discussing, amongst each other as well.
Gentlemen, I got two things. One, just because a patient or a patient family member call and say, we want the medical records now, you know, and they always call you, we want now. There's some time, there's some parameters that we have set up. It's not that we give it to them now, like we can't not give it to them if they sign a consent, but there are processes that we go through. And I'm saying that because it may be something that the doctor's coming tomorrow, that we need the doctor to finish the note or to sign a note. So we're not gonna put anybody in jeopardy if we know that that chart needs attention before we send it off. And the second thing is, we've had this happen in the past. A patient's upset, hey, I'm going back and I'm reading through these notes. Jolanda said that you paranoid schizophrenic and you very, very fidgety, reading, okay, telling the patient, this is what Jolanda said, coming from the note in Opus. Please do not do that. You may run across some patients that wanna know exactly what happened. Try to avoid that at all costs. Because that patient will never see their writing or the diagnoses or the attention to detail in their lives because they're sick. You can have some clinical documentation, they're gonna avoid that and say that that's not them at all costs. So try to make sure we're not doing that. That can cause major problems.
And the last little point I want to make is just remind everybody to keep in mind, not to leave like any type of printed documents. For example, in the morning when we have our morning staff in here, making sure that you're taking your census with you, things of that nature. Because some clients don't want other clients to know what their last names are. So that's something else to kind of keep in mind. Any hard copies, sometimes we tend to, just leave things laying around in support, leaving things laying around in here. Just make sure we're picking up behind ourselves when it comes to documents with patients' information on it. One thing I noticed too is like on the printer, just if you print something like to support, make sure you go ahead and grab it once you have it printed, because a lot of times we have a lot of just stuff just kind of lingering over there too with client information on it as well.
Also with that, like if something is printed, try not to like put it on the table or on the chair, cause like.
Just leave it on the.
Like my stuff today was on the chair where people was able to see the names.
Yeah, I would just leave it on the printer. If you know it's not for you, I would just leave it that way. The person knows that. Cause then you're like, okay, where's my stuff? I know Dominique, the other day you printed some stuff for group and you're like, where is it? And it was way somewhere else. So just, if you know you didn't print it, just leave it on the printer so the person can get it. I think that'll be probably the best solution to that. Any questions, comments, or concerns? That's it, thank y'all.